So, hi, Aaron. I've got a couple of questions for you tonight, but let's talk about what happens when somebody dies with a will.
Well, good to be here again, Kathy. Good to see you. So I know we did a series on what happens if you die without a will and transfer the car's title, and all these different things that could happen with owning real estate as well. So let's say that unfortunately, when that time comes and you pass, what does your estate do if you have a will? So again, a trust will keep you out of probate as long as nobody's fighting. If you have a will, we still need to go to probate court. But let's say that we're not going to go to probate court. In Illinois, within 30 days of somebody's passing, that will is supposed to be filed with the circuit clerk's office and an estate open. However, I've had a lot of clients who I've advised that's what needs to be done, and against my advice, they choose to still go ahead and want to sell the house, which is fine. A lot of the title companies will allow the house to be sold as long as everybody's getting along. And the paperwork that would be filed to open that estate and go through the probate process, the title companies, especially two of the big ones I work with, they will have that paperwork filled out on it's on their forms essentially. And then you can sell the home. Some of the title companies will ask for a 1 or 2% bond in lieu of going through probate to take on the risk. Because when you go through probate, there's a period where you have to either publish a notice. A lot of attorneys will publish that in the daily law bulletin. It gives creditors 6 months to submit their claim. If you don't submit a notice in the paper, then it's a 2-year period, and it can go on for a while. So if you have a will, or you've left that, you've passed, should be going through probate still. If not, there's still a way that your heirs can sell the home as long as everybody's getting along. Might be a little bit more costly, but cheaper than probate. And then if the rest of your estate is less than $100,000, you can use a small estates affidavit. If you're trying to go through all this, give us a call. We'll walk you through the process. But just know there's another alternative. There's something called a transfer and death instrument. Some attorneys like it, some don't. One attorney that I work with at one of the big title companies, he's not a fan of the transfer and death instrument. And we've talked about this before. If you have a transfer and death instrument and a will, and you don't want to put together a trust, that will transfer the property to whoever you decide after you pass away, and it becomes their piece of real estate. Totally avoids probate on the piece of real estate. The rest of your estate should still go through probate, but now when Kathy's putting together a contract, as in accepting an offer, essentially her seller is, we don't have to put the estate of or owner of record or anything like that. We would put, if Mary Smith passed away and she left it to her daughter Susie Smith, now it's Susie's home. It's actually her home because a deed called a transfer and death instrument was recorded. As long as it was properly drafted, notarized, and filed with the recorder of deeds, done correctly, it's now the daughter's property after mom passed. So if you want to know more about this, give us a call and we'll walk you through that process.
That seems like a much simpler process.
It is, and it's a lot less costly than a trust. I'm still an advocate of a trust. Um, and we went over that in another different video, but that is the best process if you're not going to do a trust, in my opinion.
Yeah, but a trust is always first. So, yeah.
Correct.
Well, thank you. I appreciate that.
You're welcome. I'm happy to, again, always answer your questions, our clients' questions.